Hi, very good morning. This is a Supreme Court judgment under the Customs Act. Citation is Patanjali Foods Limited versus Union of India. Issue is a very interesting issue whether unjust enrichment principle applies to bank guarantee furnished by the assessee to protect the interest of the revenue. That is the issue. Facts of the case, I am cutting down unimportant things. Appellant imported some goods. Don't worry about the goods, whatever it is. Some goods he imported. He filed a bill of entry for home consumption. Customs department did not clear the goods on the ground that the appellant has to pay higher duty based on a notification issued by the government under section 14(2) of Customs Act. Again, don't worry about that notification. The contention of the department is you have to pay higher duty. Appellant said that at the time of import of the goods, notification prescribing higher rate of duty did not come into existence. So I need not have to pay higher duty. That is the contention of the appellant. Department did not agree, as usually. Goods were held up, so appellant moved the High Court for release of goods. High Court directed the appellant to furnish bank guarantee and clear the goods. During the time till the writ petition is finally decided, you furnish bank guarantee and clear the goods. Interim order. So, appellant cleared the goods. Finally, High Court dismissed the writ petition. High Court held that you have to pay a higher rate of duty. Appellant approached the Supreme Court against the order of the High Court. When the matter was pending in Supreme Court, department encashed the bank guarantee because writ petition was dismissed by the High Court. Supreme Court allowed the appeal of the appellant on the ground that even though the notification was published, it was not available for sale. Hence, the higher rate of duty did not come into existence. On that basis, Supreme Court allowed the appeal. Appellant then, after the order of the Supreme Court, he filed a refund application seeking refund of the differential duty. Department refused to grant the refund on two grounds. One is non-filing of application in the proper format. It's a frivolous ground, so not so much material. Second is non-production of documents like balance sheet and profit and loss account. To prove that the claim is not hit by principle of unjust enrichment, department said you produce documents and prove that you have not passed on the duty to your customers. Appellant contended that the principle of unjust enrichment is not applicable to the facts of this case. As per the appellant, bank guarantee was only furnished as security to secure the differential duty as per the order of the High Court. I only furnish a bank guarantee. The bank guarantee encashed by the department has become refundable in view of the Supreme Court judgment. So, where is the question of my producing documents to prove that duty has not been passed on to my customers? So, appellant said no need to produce the documents. You refund the duty, which you have encashed by encashing the bank guarantees. Department did not yield. Nothing happened with regard to the refund. So appellant again moved the High Court by way of a writ petition, seeking direction to the department to refund the amount covered by the bank guarantee, which was, according to the appellant, forcibly encashed by the department. Without the appellant also said no document should be insisted from him for uh, uh, proving unjust enrichment. High Court dismissed the writ petition, directed the department to refund the amount if the appellant produces the documents establishing that he has not passed on the duty to the customers. That is balance sheet, profit and loss account, etc. You have to produce before the department to claim refund. On that ground, the High Court dismissed the writ petition. Again, appellant moved the Supreme Court. Supreme Court, it had a look at Section 27 of Customs Act, which provides for refund, and also the principles laid down in Mafatlal Industries case, famous case. So there were 7 points which I am not explaining. So it looked into the Mafatlal Industries case, the grounds on which unjust enrichment principle will be applicable. Supreme Court also noted the ratio of the judgment in Oswald Agro Mills case, wherein the Supreme Court held that furnishing of bank guarantee for all or part of the disputed duty pursuant to an order of court is not equivalent to payment of amount of duty. This is what Supreme Court said. If some bank guarantee is given, then it will not amount to payment of duty. Simply put, that is what Supreme Court said in Oswald Agro Mills case. Supreme Court said in the present case, it is true that in the initial round of litigation, High Court dismissed the claim of the appellant that they were not required to pay a higher custom duty. That is what they said. The appellant said notification did not come into existence. So I need not have to pay a higher rate of duty. That was dismissed by the High Court. After the dismissal of the writ petition, appellant filed the SLP before the Supreme Court. Supreme Court noted that there was no interim order for the BGS. This line of the Supreme Court judgment is very important. There was also no direction, either or leave granted by the High Court to the department to encash the bank guarantees furnished by the appellant covering the differential amount of duty. So, what Supreme Court says is, when High Court dismissed the writ petition, there was no direction by the High Court, either or leave granted by the High Court to the department to encash the bank guarantees furnished by the appellant covering the differential amount of duty. So there was no extension of the bank guarantee. That is what the Supreme Court says. We'll go. Without waiting for the decision of the Supreme Court, because SLP has been filed. So without waiting for the decision of the Supreme Court, revenue displayed extreme haste and encashed the bank guarantee. Ultimately, Supreme Court held that the concerned notification was not offered for sale by the board when the imported goods were cleared. Therefore, it was not justified and lawful on the part of the department to claim the differential amount of duty on the basis of the said notification. This is what happened already. Supreme Court held that the department recovered the differential amount of duty by adopting coercive method, that is encashment of bank guarantees which were offered as security for the differential amount of duty after the dismissal of the writ petition by the High Court. Under the scheme of the Customs Act, duty is assessed provisionally or finally, whereafter an assessment order or order in original is passed. Post assessment order or order in original, the concerned importer is required to pay the assessed duty. If the importer does not pay the duty, revenue can enforce recovery under Section 142 of the Customs Act as recovery of sums due to the government. So, post assessment, the government can recover the duty. The key word in Section 27 of the Customs Act is paid. Refund thereunder is permissible only if any duty is paid by the claimant, which subsequently becomes refundable either fully or in part. So, unless the assessee has paid the duty, then it amounts to payment. It distinguishes between levy and collection. Supreme Court held that in the facts of the present case, encashment of bank guarantees offered as security cannot be treated as payment of customs duty. Very, very important. Encashment of bank guarantees offered as security cannot be treated as payment of customs duty. In the opinion of the Supreme Court, department could have either awaited the decision of Supreme Court or could have directed the appellant to renew the bank guarantees. This they did not do so. The department did not do so. Instead, they resorted to arbitrary encashment of the bank guarantees. That is what Supreme Court says. Such encashment of bank guarantees cannot be treated as payment of duty or duty paid by a claimant. That is the assessee. In such circumstances, doctrine of unjust enrichment or section 27 of the Customs Act would not be applicable. It is evidently clear that the department are holding on to the money of the appellant, which they are not authorized to do so as per the judgment of this court in Param Industries Limited. That is the case in which the Supreme Court said the notification prescribing higher rate of duty did not come into existence because it was not available for sale, on the basis of which the appellant is claiming refund now. This was the case in which Supreme Court decided. That is what I said. Then the Supreme Court said they have no authority. The department has no authority in law to hold on to such money, and therefore the same has become totally untenable. Supreme Court directed the department to refund the amount along with interest. Finally, they said you refund the interest because they have furnished a bank guarantee which you have encashed. So, my comments. Simply put, the doubt is High Court dismissed the writ petition. During the interim period, High Court said you furnish bank guarantee covering the differential amount of duty. So once the High Court, when it dismisses the writ petition, will not the interim order stands automatically vacated? Is my question. Once the main writ petition itself is dismissed, where is the question of interim order surviving? Because main writ petition dismissed, interim order will automatically get vacated. If somebody furnishes a bank guarantee as per order of High Court, finally High Court dismisses the writ petition, should the department wait and see whether the appellant has filed a SLP? Should the department wait whether the appellant will file a SLP? And what will be the decision of the Supreme Court? Till that time, I will not. Because department is already having an order in its favor. Then the second question of mine is whether filing of SLP against an order of High Court, will it amount to automatic stay of encashment of bank guarantee or recovery of duty in the absence of specific order from Supreme Court? There is no order from the Supreme Court saying you extend the bank guarantee or directing the department don't encash the bank guarantee till I decide. No such order has been passed by the Supreme Court. Is it not the third question is it not the assessee who should have asked for interim protection for extending the bank guarantee? Suppose if the assessee is interested, when his writ petition got dismissed, even then when they filed an SLP, there is no need for me to wait. Once your writ petition is dismissed, department is 100% right in encashing the bank guarantee according to me. Why should I wait? Because there is no order stating that I should not encash the bank guarantee. Otherwise, the assessee should have asked the High Court itself, we are going to file SLP, please extend the interim protection by extending the bank guarantee. We will furnish the bank guarantee. Assessee should have asked. Why department should go and say, please sir, you please extend the bank guarantee? Why should department say it is having a final order in its favor? So why should department seek the permission to either extend the bank guarantee or encash the bank guarantee? That question does not arise according to me. I doubt, with regard to that part of the judgment of the Supreme Court, mildly when I put it, I doubt the correctness of this Supreme Court in this case on that ground alone. Thank you very much. Have a great day.